Right, Melissa, what do you have on this ruling?
So I think this is actually quite big. So the court has preserved access to mifepristone through telehealth and through the mails while this litigation is pending. This is definitely going up to the Supreme Court, though. And I will note this order has two notable dissents. Justice Thomas has dissented. He argues that the manufacturers here may not satisfy the requirements for standing. They may not be sufficiently injured. He also says that he writes separately to note, quote, that as Louisiana has argued below, it is a criminal offense to ship mifepristone for use in abortion. The Comstock Act bans the males to ship any drug for producing abortion. The Comstock Act is that law from the Victorian age that is literally a zombie law lying dormant that could effectively be a nationwide ban on abortion if the Justice Department decided to enforce it. It has been lying there. Justice Thomas is attempting to resurrect that. That argument is going to be stewarded through the lower federal courts and will eventually make its way up. It is an off-the-wall argument that is going to be on the wall very soon. Justice Alito also dissents. He says this is an unreasoned order that is remarkable. And what is at stake here is what he calls the perpetration of a scheme to undermine our decision in Dobbs versus Jackson Women's Health Organization. Dobbs is obviously the decision that overruled Roe versus Wade. Justice Alito wrote that decision. When he wrote that decision, he insisted that we were doing nothing more than returning the fraught question of abortion back to the states to make decisions in their own state legislatures about access to abortion. Here, though, it seems that the availability of mifepristone undermines, to a degree that Justice Alito finds concerning, Louisiana's opportunity to make abortion and medication abortion inaccessible to Louisianans.
Take me a step back, if you can, and how we got to this specific moment, because this happened very quickly over the last couple of weeks between the attempt to ban it nationwide and the Supreme Court stepping in saying no, but then now having even more of an update with this ruling today, and ultimately when it will likely play out definitively.
Right. So what we had a few weeks ago is the Fifth Circuit. There was a filing in Louisiana. A judge in Louisiana issued a ruling. It was appealed to the Fifth Circuit. The Fifth Circuit issued an injunction that effectively banned mifepristone being distributed through the telehealth and via the mails for the entire nation. So again, and if you're wondering why there's a nationwide injunction when it seemed like in the birthright citizenship case we couldn't have nationwide injunctions, this is one of those exceptions that the court allowed for in the Trump versus Casa case for agency review decisions, a review of agency decisions. So that's why you can have a nationwide injunction in this particular situation. The manufacturers of mifepristone, Danco and GenBioPro, appealed that nationwide ban to the Supreme Court. Justice Alito was the Fifth Circuit justice who received that petition. He issued a one-week stay. That stay elapsed on Monday. The stay was extended until today. Now we have the court effectively staying the Fifth Circuit's ruling. That means now they've lifted the injunction and mifepristone will be available through telehealth and through the mails for the foreseeable future until there is a ruling, ultimately, I think, by the United States Supreme Court on this ultimate question of whether the FDA's approval of mifepristone was faulty. That case had been brought to the court about 2 years ago in a case called FDA versus Alliance for Hippocratic Medicine. The court there said that the pro-life doctors and dentists who brought that case lacked standing, and they kicked it out, but they didn't address the underlying substantive question of whether the FDA had properly approved mifepristone. That's still lying out here. That is the question the Fifth Circuit attempted to answer. That's the question that continues to live, and that's the question the court is ultimately going to have to answer.
Do you have a sense of when that will take place?
The court could fast-track this in this term. I think that's unlikely. We're already moving into June. This is usually when the court winds down. I haven't read the end to see if there is more in terms of scheduling, but I think it's more likely that this is something that gets docketed for next term. It has to go, again, there's more litigation, and there may be more litigation that goes through the Fifth Circuit, but this is coming back to the court. We just don't know when.
Let me just ask you one more quick one, and that is, from what you just read really quickly, do you get a sense of what the justices thinking are going ahead into the final decision?
So that's the great thing about the shadow docket. Right. No, it's, they issued this very terse order restoring access to mifepristone. The only reason I know anything about Justice Thomas deciding to make this whole statement about the Comstock Act, nobody was talking about the Comstock Act. So this is, sua sponte, he's brought this up. And that I know Justice Alito thinks all of this undermines Dobbs is because they chose to dissent. If they didn't choose to weigh in, we would not know anything. But now I think we understand there are at least 2 votes to kill access to mifepristone on this court.
Nationwide. So, Lisa, give me your initial reaction to this breaking news.
So I've been looking at Justice Alito's dissent as Melissa has been talking and recapping quite capably how we got to this point. But one of the things that Justice Alito says that I find particularly disingenuous is that this is an undermining of the Dobbs decision. The Dobbs decision says 8 ways from Sunday that states, and specifically the people, should be allowed to decide the issue of abortion. And yet, it seems like Justice Alito would rather have a nationwide stay on the FDA's policy allowing the prescription of mifepristone through telehealth, through the mails, than allow states to make those decisions for themselves. And I want to read from the first paragraph of his dissent as I can. He says, what is at stake is the perpetration of a scheme to undermine our decision in Dobbs versus Jackson Women's Health Organization, which restored the right of each state to decide how to regulate abortion within its borders. Some states responded to Dobbs by making it even easier to obtain an abortion than it was before, and that is their prerogative. If that's their prerogative, how an order that effectively means that women living in those states, including New York, for example, if an order that would prohibit them from accessing mifepristone through telehealth appointments, an order that would prohibit them from accessing mifepristone through the mail, I'm not sure how that honors the will of the people or the prerogatives of the states that Justice Alito says is somehow dishonored by the court's 1-paragraph ruling today.
So, Melissa, the other part of this, as you mentioned, was potentially what Clarence Thomas referenced, is
right.
Do they even have standing to address this issue? And that is in reference to the manufacturers, or
exactly,
in this case.
Right. So Justice Thomas says that their injuries, which are basically the reduction in profits that they derive from selling mifepristone, I would deny their applications because they have not satisfied their burden for securing interim relief, basically saying there isn't irreparable harm here. That might relate to the question of standing. Hard to say. I think it's likely that that won't be an issue going forward. I think this is really about the standard for preliminary interim relief. In terms of the question you asked about, when is this coming back to the court? So in my zeal to get to all of this, I overlooked this statement from the court. So the injunction is stayed pending disposition of the appeal and disposition of a writ for certiorari if such writ is timely sought. So this is now up to the state to seek a writ of certiorari before the court. The court could decide to grant that. If the writ of certiorari is denied, this stay shall terminate automatically. In the event certiorari is granted, the stay shall terminate upon sending down the judgment of this court. So that is where we are. I think this is likely coming back to the court.
And I think a lot of people thought that would happen.
Well, it was predicted. The court talked about how they were settling this fraught question of abortion by returning it to the states, but everyone talked about the availability of medication abortion, which made the whole idea of state laws against abortion just really not relevant because you could get it via the mails or telehealth. This raises, I think, real questions about the Comstock Act. You don't need a court order to end availability of mifepristone. All you need is a Justice Department, maybe with an eager acting Attorney General who is now willing to enforce the Comstock Act. The one thing that may be a hedge here is that this administration does not want to talk about abortion at all. They know it's a losing issue, especially heading into the midterms. I will say, although they don't want to talk about abortion, they have launched new reviews of the FDA's decision-making, and those reviews were exactly what the Fifth Circuit cited in ultimately ending mifepristone access in that decision.
Yeah, I was going to say it may not be political, but certainly ideological for this administration. So we'll see. If you're just tuning in, we had some breaking news a few minutes ago. The Supreme Court ruling to preserve abortion pill access, at least for now, and we'll see when it works its way to the Supreme Court. Lisa Rubin, thank you so much. Melissa, please stay with us.